Hello. In this episode of On Subrogation, we're going to discuss the Independent Contractor Defense to a Vicarious Liability argument. I'm Kim Rathbone, your host for this episode. In a prior episode, we talked about vicarious liability, which is where a third party can be held liable for the negligent acts of another. And one of the most common circumstances where that arises is that when there's an employer-employee. But one of the biggest defenses that occurs is an employer saying, I can't be held liable for the negligent acts of that person because they're not an employee, they're an independent contractor. And that is the general rule. Employers cannot be held liable for the acts of their independent contractors. However, there are so many circumstances where the employer claims that the employee is really an independent contractor when they're really an employee. There are some clear exceptions to the independent contractor doctrine where the employer can be held liable. One of those is when the employer negligently supervises or instructs the contractor. An example of that would be a failure to inspect the work after completion. In those circumstances, the employer can still be held directly liable for the damage that occurs by the contractor. Another circumstance is that where the action of the independent contractor is a non-delegable duty in relation to the public. So an example of this would be if there was a trucker that is driving along the highway and is transporting large logs on the highway and those logs weren't properly secured. The fact that they weren't properly secured by the contractor doesn't prevent the employer from being held liable also because there is a non-delegable duty to keep the public safe when completing that action. So in those circumstances, the employer and the independent contractor would be held liable for the independent contractor's actions. Another exception is when the work performed is inherently dangerous. An example of that would be, again, in the trucking circumstance when there is a flammable substance that is being transported on the highway. Under those circumstances, if the action is just too dangerous to the public, it's impossible for the employer to say, hey, it's the independent contractor's responsibility only because they are not able to contract away that liability by passing it off to the independent contractor. And also, whenever there are materials being transported through interstate motor carriers, there is a Federal Motor Safety Regulations Act that governs those actions as well, and those can hold the employer liable as well. It's not just these exceptions that could hold an employer liable for an independent contractor's actions. There are other tests having to do with how much control the employer has over the independent contractor's actions. And there are several tests throughout the country with different names that apply to this. One of them is the economic realities test. Another one is the common law test, also called the IRS 20-factor test. And another one is called the ABC test. These are all very fact-intensive investigations, and they analyze just how much control an employer has over how the independent contractor is doing their job. The first thing to analyze is the overall relationship between the employer and the independent contractor. For example, if their relationship is a continuous one, that would indicate that it's a relationship more of employer-employee. If the contractor is hired on an as-needed basis, that would indicate that it is more of an independent contractor relationship. If the contractor works at the exclusion of that employer to all other employers, well, that's an indication of control, and that's going to be more of an employer-employee relationship. If the regular business of the employer differs from that of the independent contractor, that's an indication of more of it being an independent contractor relationship as opposed to employer-employee. If the employee has specialized skills then that's going to be more of an independent contractor also. If they're less specialized skills, it'd be analyzed to be more of an employee. If the occupation is done without any kind of supervision, then that would be an indication more of independent contractor. The more supervision that the employer provides, the more likely it'll be held to be an employer-employee relationship. Certainly the easiest way to analyze this is to see if there's a contract, an employment contract, that exists between the employer and the independent contractor. That will help to walk through tons of different factors that exist to help define what their relationship actually is beyond just what the title of independent contractor is. As you can see from some of these examples, the more control that the employer has over the independent contractor, the more likely it is that that title of independent contractor is going to be thrown out and the employer-employee relationship will exist. And you want that because that's when you can hold the employer liable for the acts of the independent contractor. But the facts get drilled down even more. There are several that have to do with staffing that we can analyze as well. If there are particular staffing requirements that the employer has, like a certain number of employees, or if there are background checks that have to be determined before an employee or an employee of the independent contractor can come onto the job, well, that's an indication of more control and more of an employer-employee relationship. Anything that shows that the requirements of the employer are going above and beyond just providing a competent level of work, that is more of an employer-employee relationship as well. If the employer is providing training to the independent contractor, well, that's an indication that it's more of an employee relationship as well. If there are audits on quality of performance, then that is another indication. If there are requirements on the dates that the employees can work, or the holidays that they can work, or even the hours within the days, even if they're best recommended hours, all of those things are going to lend themselves more to an employer-employee relationship. And certainly there are visual cues to this as well. It could be logos on a uniform of the independent contractor. If that logo is of the employer, well, that's an indication that it's more of an employer-employee relationship. The same goes if it's on a vehicle, if it's on a contract between the insured and the contractor. If any of those things has the employer's logo on them, well, that sure makes it seem like the independent contractor is an employee of the employer. Some even have something called grooming requirements, where you have a certain amount of appearance that is required in order to be an independent contractor on the job of the employer. That, of course, is going to indicate more control and going to be more indicative of the employer-employee relationship. But there are also factors that you might expect with regard to pay. If the employee is paid either by the hour or on a salary basis, that's going to be more of an employee. But if it's more on a pay per service or pay per job indication, then that's more of a contractor-employer relationship. If the employer is providing benefits to the independent contractor, well, that's certainly more of an employee-employer relationship. And a 1099 tax treatment that the employer might give to the independent contractor, well, that's going to be more of one of an independent contractor. If the employer is paying the contractor directly as opposed to the insured paying the contractor, well, then that's going to be more of an indication of an employer-employee relationship as well. There are also indications of control over the job itself that come into play. It could be how many instructions is the employer providing to the independent contractor in order to complete the job. Does the employer have the right to stop the work and inspect the progress, change any details with regard to how the job is going, or even provide alterations or deviations to what was originally occurring? There could be requirements regarding security checks or certain procedures that need to be followed. There could be particular materials or tools or personnel that are required to be used on the job by the employer. It could be that the employer owns the tools or maybe the vehicles that are used on the job itself. And it could be that the employer chooses the routes, if it's done through a vehicle, that the independent contractor has to drive in order to complete the job. In all of these things, the employer has to assert more control than just occasionally. So if it's just intermittent instructions, it's really not going to lend itself to employer-employee relationship. That would be more of an independent contractor. If they make only the odd rule or regulation over the contractor, it's probably not going to be enough. If there's additional projects that are assigned later on, then that could be potential control by the employer. And then when the job is complete, if the employer is requiring the contractor to write reports or meet a certain number of quotas or provide reports regarding compliance when the job is complete, that can lend itself to the employer having more control over the independent contractor as well. Even if only some of these factors come into play to create that employer-employee relationship instead of that of an independent contractor, it doesn't matter. Just as long as there's more than not that's present, that's what will create the argument for that employer-employee relationship that will hold the employer responsible for the so-called independent contractor's work. The way I tend to look at it is, if I'm the insured, what perspective do I have about the independent contractor? Do they seem like they're a completely different third party separate from the employer? Do they actually look like an employee to me of the employer? And that's where those logos come into play, vehicles come into play. You know, what is it about the independent contractor that the insured understands is different from that of the employer? And then when you put all the factors together, I imagine it to be like a tug of war. The closer that all the factors are to the employer's side, where they have more control over the rope, then the more likely it's going to be that you're going to be able to hold the employer liable. And the more likely it is that the independent contractor has control over the job, the relationship, anything involved in the transaction with the insured, the more likely that they're going to only be able to hold the independent contractor liable and not also be able to bring in the employer. So when you're investigating claims or when you're litigating a subrogation case, it's important to fight to get these details. So they aren't always readily available. And if they aren't favorable, they're sure not going to want to turn them over to you. For On Subrogation, I'm Kim Rathbone. That's the long and short of it.